Welcome to Case by Case, a podcast put together by Luke Zadkovich and Calum Chain of Zyla Floyd Zadkovich. Welcome, Calum.
Thank you, Luke. Another good case today.
I've got to say, I don't think I've been as excited about doing one of these case by case podcast episodes as I have been today.
It's an interesting case. There are so many different issues in this case, and the subject matter is quite satisfying.
You could say that. It's got absolutely everything. We start with a Ferrari 250 GTO from the 60s without its gearbox. I think that's just a classic, how it's a $44 million sale of a Ferrari with, well, I think it's got a substitute gearbox or it drives, but its original one is not in the car.
Yeah.
The dispute is over peanuts, actually. You know, when you break it down, the parties were so close when this all kind of fell apart. On a $44 million deal, they were really only arguing over, next to nothing.
Yeah. But there's so much bad blood. Clearly, there's so much
incredible.
Bad blood between these two parties.
It's incredible.
You know what? The only thing about this case and it came right at the end that made me not like the case so much was where I found out that the seller was not located where the Ferrari actually was. And this is probably massive naivety because I don't own any $44 million cars. But the Ferrari itself was kept at in Ferrari in Italy, and the previous owner was obviously living in America or wherever. So it was just a collectible to him. There was this beautiful car, and he's presumably not even driving it.
Yeah, I'm not going to profess to know as much about fast cars as our colleague Howard Quinlivan.
Yeah.
But I do know that that's not uncommon, and that actually antique cars are kept in pristine, almost museums, like fine artwork, and they're bought as collectibles, as investments, and of course by car lovers. But they're not always stuck in a container and shipped around the world on subsequent purchases. But the case, like the legal side of the case, has everything as well. Like I'm resisting putting too many kind of driving puns into this podcast, but there's more procedural twists and turns than a Monte Carlo racetrack.
I like that. Yeah, and it's got both sides too. It's got the legal side and then it's got the procedural side. So you've got these different points of procedural law. You've got these different points of contract law. Crucially, one of the key points of contract law, I was delighted to see, as has always been the case since basically Contract Law 101 turned on looking at shipping decisions, which basically drives English contract law. No driving pun intended there. But it's got everything, like you say. There are so many issues to unpack in this case. Yeah,
and you've got one of our favourite Lord Justice's mails with a typically beautiful, if I can say, judgment. Also in the way that he just sets the party straight on mediation and how this just should not have got to where it did. He obviously, on costs, which we'll come on to probably right at the end, deals with who was more responsible or culpable for not adhering to the recommendations by Lord Justice Mails to go off and mediate this dispute in the permission granting. But it's got everything. I read it and my takeaway from this decision was this is one of those cases that should form the bedrock of a day one session at law school or something like that.
Yeah, it's the kind of fact pattern that will just be in law students' exam questions for years to come.
Yeah, exactly. Well, with all that said, I think it's fair to say, strap yourselves in, Put on your
Buckle up.
seatbelts, buckle up, exactly. Put your driving gloves on, helmets on, because we're about to drop the clutch on this one, and let's get it going. All right, Calum, open us up with some facts.
Okay, so as briefly as I can, there are two parties involved. Well, there are two principal parties involved: the seller and the buyer. The buyer is a company called Gregor Fisken Limited, a seller or a vendor of collectible cars, and the seller is Bernard Carl, who was the previous owner and the owner of the car at the time that this sale was made. And the sale was for a Ferrari 250 GTO, which if like me you are not massively into your cars, I strongly recommend Googling Ferrari 250 GTO. It's a thing of beauty, although my colleague Howard assures me that there are many nicer Porsches in this world. And it was sold for $44 million. A nice little vignette that Lord Justice Mills leads off with is that they were originally manufactured by Ferrari between 1962 and 64. And when first built, they cost $18,000, and each owner had to be personally approved by Enzo Ferrari himself. And they now go for, it seems, tens of millions of dollars with or without gearbox. And the gearbox had been separated from the car, and there's a little bit about why that happened, but it seems that basically the gearbox was at a garage owned by Mr. Bruce Canepa. Or Canepa, I'm not sure exactly how to pronounce his name, but it was in California, and it seemed as though there was at least a suggestion that the gearbox had been stripped and stolen by a disgruntled employee of Mr. Bruce Canepa, who ran a garage in California, and this entire case came down to the kind of repatriation of the gearbox to the original to the rest of the car, and there was a contractual mechanism when these two parties agreed the contract. They'd agreed that they'd noted in the contract that the car did not include the gearbox, and they had this contractual mechanism, a relatively complicated contractual mechanism that set out the different ways that the parties had kind of obligations relating to the gearbox. And one of the obligations on the seller, Mr. Carl, Bernard Carl, was to basically use his best efforts to try and find the gearbox. And having found it, there was this obligation, or at least it later became contested, but there appeared to be this obligation on the buyer to pay an additional $500,000 if the gearbox was found and made available to him.
Yeah. So we had, just to recap, we had a sale of the Ferrari, this 1960s beautiful Ferrari, for $44 million. And it was clarified in this decision that the $44 million was consideration for the car and the gearbox, even though the gearbox was outside of the car. And because the gearbox was not actually in the possession of the seller, it was with someone else, and as you say, perhaps with a disgruntled employee of that someone else, there was this mechanism for retrieving the gearbox. And if that was done, there was a kicker of $500,000 that would be paid by the buyer to the seller.
Yeah, exactly. And the whole case turns on this $500 and finding the gearbox. But the gearbox is found quite quickly. They find it with Mr. Bruce Canepa, and you think at that stage, and this is effectively when we get onto procedures, this is the judge's point of procedure, is you've got the gearbox. You know that you have to pay an extra $500,000 for the gearbox. You should have sorted this out. This should have been sorted out. But rather than being sorted out, you have this explosion of litigation where the gearbox, first there are questions about whether the buyer has an entitlement to inspect the gearbox or to have the gearbox inspected. Then there are questions about where the gearbox has to be inspected and who has to come and inspect it, and whether they need Ferrari expertise to go and inspect the gearbox to make sure that it is the correct gearbox. And then you have questions about where the gearbox has to be delivered, whether it is simply turned over at the place where the gearbox currently is, or whether it has to be delivered to a particular location. And then you get into questions about whether or not the further payment of $500,000 is actually a requirement in order for the gearbox to be sent. And then you got into even more questions about whether the contract even existed in the first place.
Yeah, that's when it just got ridiculous at the end there. Insane. But just pausing for a moment, when I went through this judgment and read the correspondence, you could kind of see, the toing and froing over this, and how in commercial terms one party may have a bit of a point, and Mr. Carl had found the gearbox. Canepa didn't want to turn over the gearbox to Carl until he got paid and released from any issues, which I could understand that. Carl, instead of just paying the $25,000 and then getting the $500,000 from the buyer, then gets into this stoush about, well, I want to be paid the money first, so then I'm not out of pocket to then pay on Mr. Canepa, the person who they secured the gearbox from. And this kind of toing and froing went back and forth over, and also the inspection right or lack of right started to be debated. Then Carl was trying to propose new contracts to deal with this when there was already an existing contract. But what I thought was really interesting when I read through this correspondence, and I'll just make sure that I get the right reference here, it was the message at paras 31 and again on, was it 31? I think it was 31 and 40, or at least it was the message on paragraph 40, where the buyer ultimately says, look, let's cut through all this. We will pay the $25,000 to Canepa to get the gearbox, so you're not out of pocket, seller. We'll then get this gearbox over to Italy to get it authenticated. If it's the right gearbox, as in if this was the gearbox that was in this Ferrari, we will then pay the $475,000. And my understanding of the contract was that was pretty much what was supposed to happen. Now, there was a debate about whether the inspection should be in Italy, who foots the bill for sending the car over there, and the Lord Justice Males in this ultimately says, well, that wasn't necessary. The inspection could have happened in California. But that's a side point. The fundamental issue here is that there was a reasonable proposal made by one of the parties back in 2018 to resolve this in a sensible way, and it was dismissed out of hand. And that dismissal has had significant consequences for the seller in this case, on costs and time and all the rest of it. But it's a real lesson for me in pre-litigation correspondence, to be guiding clients and advising clients. Well, look, there might be commercial considerations here. You might be annoyed at the deal you've struck. Yes, you're annoyed that you didn't know he was buying as principal, perhaps subjectively, or that he was going to stand to make a big profit on the next sale of the gearbox or of the car. All of that, I know it might be annoying for you commercially, but that's not going to be the outcome of this from a legal perspective. And you can't help but think that at that point, someone had to be convincing Mr. Carl, this is a good deal. Let's debate how the inspection happens, but accept this deal, move on, and get on with life.
Yeah. I mean, Mr. Carl, I looked him up. You know who, I think at least, he is a lawyer himself.
Oh, really?
Okay. Clearly.
Well, yeah, okay.
he's clearly in the right line of legal work if he's got $44.5 million. If he's got a Ferrari 250 GTO. But yeah, I think he's a Washington-based lawyer, and I'm not certain. I just think that I came across that when I was looking into the background of this case, and if so, all of the procedural issues that you mentioned, all the difficulties that the Court of Appeal and Lord Justice Mills in particular had with the way the case was pleaded, all the problems that they had with the way that new claims were brought, the procedural issues that all came about. It is surprising to me that someone with a legal background would take this case so far.
Is it though?
Well, that's the alternative. We all know that person.
Exactly. Isn't it the old adage that, lawyers just should not try their own cases? This is almost a sorry tale for that. Although he may have had quite a bit of money to play around with from that 44 million that he made. So
that's true. I'd hate to see how much of it he lost in costs.
Yeah, a good chunk. He did though get back his 500k out of this.
That's true.
I think there would have been some solace at the end of the decision. Okay, all right. Well, with all that, let's get into the legal issues. The first legal issue that was taken up and really seemed to be the main argument in the appeal was whether GFL, the entity that went down on the sales contract as the buyer, whether they were in fact a party to the contract. And this arose because the contract, in describing the buyer, referred to GFL as being an agent for an undisclosed principal, but GFL went on to sign the contract without any caveat or without any reference to acting as an agent. And in addition to that, there was an addendum, the bill of sale, which was set out in an unqualified way as well as to the buyer. So it didn't say on that bill of sale that the buyer was acting as agent for anyone else. And so there was this question, a threshold question, as to who was the buying party to this contract. Was it GFL as agent for some other principal, or was it GFL in their own right? And this was important because it turned out that there was not an undisclosed principal. GFL was in effect trading this deal. They were buying it as principal and then selling for a profit onto the next buyer. And the argument that was had in the appeal was, were they acting as agent or were they acting in their own right?
And I think this is something this point of law is really of critical importance in the world of international trade and particularly shipping, because we see so many contracts where you have kind of management companies entering into charter parties or other agreements as agent for or as principal on behalf of special purpose vehicle companies or sometimes unidentified companies who will later be known. I guess what I'm trying to say is that occasionally you'll have a charter party which is entered into in advance, where the principal is not disclosed or identified at that early stage and is going to be later identified and made known to the parties.
Yeah, exactly. And I just like how we started off on a case regarding a Ferrari, and we end up pulling in shipping cases. We can't get away from shipping law in one way or another.
Exactly. You start with a Ferrari GT250 and then you just move up in the glamour stakes to a bit Exactly. And look, the argument was that these shipping cases are irrelevant. Why do these decisions relating to whether shipping charter party describes the owners as the owners or the owners as agents for someone else, why does that have relevance here in this sale of goods scenario for a car? Yeah, and I was pleased to see that Lord Justice Mayles gave that short shrift. They're of general application, these principles, and the principle itself was one that I think bears repeating, and it's certainly clarified as a matter of law in this judgment, which is that where you sign a contract in your own capacity, or you don't put the signed as agent only. That's the wording that we typically see. Signed as agent only, and then the signature of the signing party. If you don't do that, then you're broadly taken to have entered into the document entered into that contract in the capacity as principal, even if at the top of the document it says, say it's you and I entering into a contract. If it says Calum Chain as agent for a unidentified principal, if at the bottom of the contract I sign it off as Calum Chain without saying as agent or as agent only or as agent for an unidentified principal, then the way that the law will treat that is that I've entered into that agreement as myself.
Yeah, exactly. And I hadn't appreciated how strong that law was, because over years, decades now, I've been looking at these shipping emails, shipping contracts, and as agents is always invariably there in a signature line or at the bottom of a contract. And I always thought of that pretty much as a belt and braces type approach. Let's just make sure that it's clear that we're acting as agents only here. But it goes beyond that, actually. And as a matter of law, if the contract is signed off in an unqualified way, as you say, and does not include the words as agents or something like that, then that signature in an unqualified way will have prevalence, will have priority over what else is said in the contract, assuming that the contract itself does not make it very clear that this contract is being entered into for a principal. So in this case, it wasn't very clear. There was a mere description in the buyer, the name of the buyer at the top of the contract, that it's acting as agent for an undisclosed principal. But the contract itself, in the operative provisions, didn't go on to explain what the agency relationship was, didn't say anything about the principal. And moreover, as I said before, the bill of sale that was an addendum to the contract, it seemed to suggest the opposite, that the buyer was entering into the contract in their own name as principal. And so here there was inconsistency, again bringing back a prior episode where we talked about inconsistency of terms, but here there was an inconsistency between the description of the buyer at the top of the contract and then this unqualified signature at the end. And the legal principle to take away from this is that the unqualified signature, where the person puts their name, where they're signing off, that has precedence, that outweighs the unclear references in the rest of the contract.
Yeah, so it's a point to be very careful with when you're contracting. As I had the same view that you had, which was that it was a belt and braces approach to, say as agent only. Sometimes you even see it on stamps. When the people stamp a signature, it will say as agents only. And I too thought that was mainly just belt and braces, but it's actually it's of critical importance. If you're signing a document as an agent, then you have to mark beside your signature that you're signing in that capacity.
Yeah, and the cases on this are old. We've got Cook and Wilson from 1856, Parker and Winlow, 1857, the Frost Express, okay, that's in the 90s, 1996. But we're talking about old principle here that I know I personally haven't had cause to look at in a while, or look closely at this principle, but it's a long-standing principle. And it's reaffirmed here as a long-standing principle, and indeed almost so that Lord Justice Mayles felt that he couldn't go back and revisit it, almost in a way. This principle has been, how did he put it? Here it is. If the contract contains no other means of resolving the inconsistency, English law has decided that the signature is the predominating consideration and has maintained that position over the last 150 years or so. It is too late to change that now without introducing considerable uncertainty into our law of contract.
So as far as that issue is concerned, there we have it. I think that's the that's the clear ratio.
So there was a contract. So we have a contract.
Exactly, and the next question then, following the determination that there was a contract in place, was the question of whether or not that contract incorporated the Sale of Goods Act under English law. And if a contract incorporates the Sale of Goods Act, that brings with it a number of implied terms, a number of points regarding the passing of title, regarding the place of delivery. It was the same issue, in fact, that was critical to the OW Bunkers case in the Res Cogitans. That was all about whether or not the Sale of Goods Act was incorporated into the contract because of the implied terms that went along with the Sale of Goods Act. So it's a question that comes up not infrequently on sale of goods cases, and in each case it's relatively it's a relatively fact-intense determination, but it is something to be aware of when you're entering into a contract for the sale of goods, understanding the position with respect to the Sale of Goods Act and whether those terms, the terms that are incorporated by that act, also form a part of your contract is important.
Yes. And the way that the court went about answering the various issues before it by reference to the Sale of Goods Act is instructive. And it's instructive in the sense of how to approach these cases from a practitioner's perspective. As lawyers, how should we advise our clients on these issues? How should we structure our claims or our defences? How to apply the analysis to a sale of goods? And once Lord Justice Mayles took that view on the court here, it was actually a 3-justice decision with the other 2 justices concurring. When the court took the view that the Sale of Goods Act applied, it then went on and assessed all of the ancillary questions by reference first to what does the Sale of Goods Act say.
Yeah, and perhaps we move. So the question of whether or not the Sale of Goods Act applies, absent anything else in the contract, is simply looking at whether or not it satisfies the definition at Section 2, subsection 1 of the Sale of Goods Act itself, which is that a contract of sale of goods is a contract by which the seller transfers or agrees to transfer the property in the goods to the buyer for a money consideration called the price. So the in terms of a kind of legal analysis, which is broader than just this decision, there's not a huge amount to discuss there because in each case that's going to turn very much on its facts. But if the contract that you're entering into satisfies that definition, then it's likely that other parts of the contract will end up being determined on the basis of Sale of Goods Act questions.
Yeah, and here the seller was trying to argue that the $500,000 kicker for getting the gearbox, that was more akin to a services type contract rather than a sale of the car and the gearbox. And as you say, the court gave that quite short shrift and found that no, this was a sale of the Ferrari and its gearbox, albeit separated from the Ferrari. And the consideration for that was the $44 million, and that there was just a mechanism for an additional payment if the gearbox was retrieved.
And I think there's an important point in the way that the judge or the Lord Justices went about this decision, which was that they effectively considered the gearbox part of the property that was the subject of the sale. The seller had title to the car and gearbox, and even though the two had been separated, the seller was still capable of transferring title to the entirety of the car, including its gearbox, under the contract of sale, and did so, and that bleeds through into a number of the different issues that were determined.
Yeah, and the threshold question there, I think, was whether property clearly passed in the Ferrari, but whether it also passed in the gearbox, even though the gearbox was not in the possession of the seller. And so going back to what I said earlier about the approach to take here, the court then, as the first thing to do in assessing that question, that passing of property, went to Section 17 of the Sale of Goods Act. And I won't read it all out here, but that section goes to ascertaining what the party's intention was. And, where it has some rules for determining that and what to do where there's no intention expressed. And in this case, there was no doubt that the intention was to pass property in the GTO, in the Ferrari, on completion. And there was an express clause in the contract that said as much. And the court then went on to say, well, there's no reason to suppose that the parties had a different intention with regard to the gearbox. And the clause that the seller referred to in having to retaining a right for the seller to bring proceedings against a third party to retrieve the gearbox didn't affect that fundamental intention. And to the contrary, there were other clauses in the contract that actually supported the intention of the parties was for the gearbox to pass, property in the gearbox to pass on completion as well.
Yeah, exactly. And the kind of the key point of general application there, as you say, is that Section 17 of the Sale of Goods Act simply says the court will look at the intention of the parties. The court will, unless it's clear from the contract, the court will look at the contract and ascertain where at what time the title was or the property was entitled to pass between the parties. So the next question then was where was the delivery going to take place? And again, as was the case with the question on title, the first place to turn to is the Sale of Goods Act, and Section 29 deals with the place of delivery. Subsection 1 effectively says the place of delivery will be the place where the contract says that it will be delivered, and subsection 2 says that it's the seller's place of business. So the court had to determine whether or not the contract stipulated the place of delivery of the gearbox. That was the inquiry for the court, essentially. And they looked at the wording of the contract that said that the gearbox would be turned over to the seller, and they effectively said that turned over meant it's kind of yours where is, basically. Once we find it, we just turn it over to you.
Yeah.
It's up to you to deal with it from there.
Exactly. That it's available for collection wherever it may be. And that makes sense. I think that is the natural understanding of turn the gearbox over to the buyer. So yeah, that was a relatively short point. There was also this point about examination of the gearbox. It was a separate question, dealt with separately. Again, the court first looked at what the Sale of Goods Act says. In this instance, that was Section 34(1) of the Act. And this is worth reading out, I think, because it's a point that might not be obvious to many of our listeners. So Section 34(1) of the Sale of Goods Act provides that unless otherwise agreed, when the seller tenders delivery of the goods to the buyer, he/should be she is bound on request to afford the buyer a reasonable opportunity of examining the goods for the purpose of ascertaining whether they are in conformity with the contract. And then it goes on to deal with a sale by sample. But it's this concept that there's an obligation bound on request to afford the buyer. So the seller must give the buyer a reasonable opportunity of examining the goods. And this goes back to that message that I referred to at the opening, Calum, where there was this, I thought, reasonable offer by the buyer to say, okay, we'll make sure that the $25,000 is paid through to the person that you've got this gearbox from. We will pay you the $475,000 remaining as long as we confirm that that these goods are the right goods. Now, the buyer said that has to happen in Ferrari, the Ferrari factory in Italy, meaning that the gearbox had to come from California. That was not necessarily reasonable, but the opportunity to inspect was a right of the buyer, and indeed the seller was obliged to give the buyer that right under this section of the Act.
Yeah, exactly. And they as you mentioned at the start, the court did find that the right of reasonable inspection did not extend to an obligation on the seller to send the gearbox to Ferrari in Italy from California for inspection. The Court of Appeal found that someone from Ferrari could have been flown out to the gearbox, for example. The inspection could have taken place in California, but it does go to the reasonableness of this offer that was made. Effectively, nearly, bar a few points, like the one I've just mentioned, this offer pretty much mirrored where the court went with their decision. Quite. And it kind of moves on to what I thought was another interesting point of general application, which was the seller argued, one of the seller's arguments was that offer was a repudiation of the contract. And repudiation, as a contractual term or as a piece of legal jargon, is effectively where you've breached the contract in such a significant way that the contract, that the other party, the innocent party, has a right to terminate the contract. And that requires a pretty significant breach. But one of the ways that you can repudiate is by effectively communicating to the other side that you have no intention of being bound by the terms of the agreement. And for example, in a charter party context, you might have somebody saying, I'm never going to pay you hire again. I consider that this contract is at an end. And that could well be a anticipatory repudiatory breach, which is the legal jargon for the one party saying to the other that they've got no intention of being bound by this contract going forward. And I think that was the argument that the seller was trying to make here. They were trying to say the conditions that you're putting on this sale evidence that you have no intention of being bound by the terms of the agreement that we've signed up to, because they're so far removed from the terms of the agreement that we've signed up to.
And the court just said that wasn't the case. They looked
right
at the correspondence, looked at the 21 February 2018 message that I've referred to already, and said, well, save for the point about where the inspection takes place, the buyer's position was both reasonable and also in accordance with the contract. There's in no way that message could be deemed to be a repudiation of the contract because they were asking for the inspection to take place in Italy. And there could have been some toing and froing over that, but it doesn't even get close to rising to a repudiatory type breach.
And what I thought was also interesting in this judgment, and correct, was that the Lord Justice Males contextualised this dispute in the context of the entire contract.
Yes.
He wasn't looking at the $500,000 for the engine for the gearbox. He said this is a $44.5 million sale, and you're saying that there's a repudiation on the place of testing of a component which is worth $0.5 million. And in the context of the contract as a whole, which is what you should be looking at when you're considering repudiation, this is insignificant.
Not to mention, sorry, Calum, but not to mention that $44 million was paid, the GTO was handed over, and
well, exactly.
The most of the contract was performed.
Yeah, and I think that's really quite instructive. Again, it's maybe a practitioner's point. When you're advising on these questions of repudiation and renunciation, or advising on a right to terminate, then stepping back and seeing the contract as broadly as possible and seeing whether the issue, which no doubt your client is extremely hot on in the present moment and extremely focused on in the present moment, whether that issue is of fundamental importance to the entire contract is an instructive exercise.
Yeah, super important. Really important to do that, and have that distance as well. Where we all, and I know you're like this, I'm like this. We fight our client's corner vigorously and as passionately as we can within reason. But you still need to maintain that professional distance so that you can understand your client's commercial objectives, understand their instructions, where they're coming from, but then be able to explain, as a matter of law, this is where we can take those arguments. This is how far we can take them. This is the outer perimeter of what we can do with that type of argument. And I'm not saying that wasn't done here. We have no idea what the position was between the solicitors and the clients. And indeed, at one point, leading counsel suggested that he should fall on his sword on some of the arguments, and the Lord Justice Mayles said, "Well, I'm not so sure I believe that," or words to that effect. So
I didn't get the feeling that Lord Justice Mayles particularly liked the seller.
No, I think that comes through. Although I think it's right for us to note the $500,000 and what happened.
Yes.
What happened with that? That wasn't a sale
Right.
of goods point. That was more a construction point.
Yeah, and this was essentially the disputes between the parties had got so heated and had got so blown out of proportion that, despite the fact they'd both originally agreed that finding and turning over the gearbox, the original gearbox, would entitle the seller, to an additional $500,000 from the buyer, by the point of this reaching the courts, such was the level of acrimony that the buyer had essentially said, "Well, I'm not going to pay you the extra 0.5 million. My contractual the contract that we entered into does not actually require me on its construction to pay you that additional sum," which the first instance court agreed with.
Yeah, and I was amazed by that. So that was the argument. There was that GFL, the buyer, was disputing the entitlement to the $500,000 on the basis that that was only payable if the gearbox was recovered from somebody other than Canepa, as I understand the argument.
And the contract was not that well written on this point.
That's true. Yeah, I'll give you that. And in that respect, the court went through the relevant contractual provisions and identified that some of the clauses they deal with the incurring of legal costs and compensation related to that, and then subsequent clauses deal with the allocation of compensation or damages recovered from any third party. And then finally, there was another provision that dealt with remuneration from the buyer to the seller for services in locating and then securing the possession of the gearbox. But that didn't really distinguish between whether the gearbox was recovered from Canepa or whether it was recovered from a third party, and they applied really equally in either case. And if you think about this from a commercial perspective, as the court noted, there's no real commercial sense in saying that Mr. Carl, the seller, should be incentivised to go and recover the gearbox from third parties, and if he's successful in recovering from third parties other than Canepa, he gets $500,000. But if he recovers the gearbox from Canepa, that he doesn't get the $500,000. That incentive to incentivize one and not the other just doesn't make any commercial sense. And so the court found that that's just not the construction of these series of clauses. And
there's a similarity in this case to the Septo case that was also Lord Justice Mayall's that we looked at in a previous episode.
That's right.
Which was the one about the recap, where he used a similar kind of school of contractual interpretation, if you like, where the contractual interpretation question was framed relatively literally, and he looked at the objective intention of the parties in following the guidance from the Supreme Court in cases like Arnold and Britton, which maybe tends towards a more kind of literal reading of the contracts. But there's certainly a kind of commercial interpretation which is driving some of the decisions, or it's certainly this decision in the Septo case, and I think it's done quite well. I think that there is sense where a contract is being kind of pulled apart by the courts, for the court to take a view on the commercial intention, and to have that as a factor in the way that they read the contract. Otherwise, we can come up with some fairly bizarre judgments, and the parties, when they sit down to prepare contracts, typically aren't considering all the things that could go wrong, and things go wrong that are outside of the contemplation of the parties, and the wording taking in isolation of a few different clauses can often lead to a result where the parties just weren't considering this being in that situation ever.
It's a good observation, Calum, and I'm conscious of time for this particular episode, but we could definitely get into, and maybe we should in a subsequent episode, looking at the various approaches of the courts, whether there's a tendency towards a more literal interpretation of contracts, or whether there's a more purposive, commercial type view that comes through in these decisions, and indeed whether certain justices have their own views on this. And
it will be interesting. I think it'll be interesting over time as we continue these to see if there are repeat people who come up, whether you start to get a flavour of certain justices' style, if you like.
I had one other point that I wanted to make on this, or maybe actually 2 points, if I may, just to deal with the list of issues point very briefly, and then mediation. And if you would like to wrap up on costs and sign us out, that would be great, Calum. I think if we could probably do this in relatively short order. On the list of issues, I thought, again, practitioner's note here, the court expressly noted that in this case there was a list of 25 odd issues, which was in effect a rehash of the pleadings, and that's not the point of a list of issues. A list of issues is supposed to distill the principal issues of fact and law arising in the case, emphasise the word principle. And I think that's important for us all to know as practitioners in drafting lists of issues for commercial court cases. The other point is mediation. Mediation does have a place in English and US legal practice. It's actively encouraged by the courts. Some cases are not prime for mediation. Most should at least be considered for mediation. This is a classic case where you can just see that had a mediator sat the parties down around a table and said, look, we are actually arguing here about whether an inspection takes place and where it takes place. You've got potentially £1 million worth of costs in front of you, taking this all the way up to the Court of Appeal on these points Of course, they wouldn't have known that when they set out, but you've got at least significant costs ahead of you. Let's work out some regime to deal with this inspection where it happens and make it reasonable. Had that happened at an early stage, then significant costs could have been avoided. Moreover, in this particular case, when Lord Justice Males heard the permission application and gave permission for the hearing, I suspect what happened was he saw that there was an issue over the 500,000 and that should have been awarded. And in granting permission, basically said to the parties that that's going to be the outcome, go off and mediate. And the appellant didn't take heed of that suggestion and was then ultimately punished on costs, which is your segue into just wrapping up what happened on costs.
Yeah, so there is a procedure in the courts, which is people often seek to mirror this procedure in arbitration. There are various reasons why it doesn't mirror exactly, but the principle stands. The principle is good, which is that if you make an offer and the terms of your offer would give your opposing party a better result than what they ultimately obtained by going all the way to a decision, then when it comes to a costs award, you can turn around to the judge and say, hey, look, we actually made them an offer and they've gone all the way to a judgment, and the judgment is worse than the offer that we made them. And if you make one of those offers early, it's called a Part 36 offer, then there are a number of cost penalties on the party that refused to accept the offer. So, one situation where you can make these kind of offers is if you are if you're a defendant to a claim, then you can even if you think that you might be liable in some way for the claim, but not for the entirety of the claim, then you can make an offer for part of the claim. And if at the end of the day the claimant gets awarded part of the gets awarded a part judgment against you as the defendant, then your Part 36 offer, this offer that you've made, can then be revealed to the court and can essentially flip the position on costs, where normally the claimant would be the successful party in that situation, but in fact you would then be considered the party who was successful for the purposes of the costs award. And that was exactly what happened here. There was a little bit of a discrepancy over things like interest, but fundamentally, because of the offer that was made early on in proceedings, where the buyer had said, I'm going to pay you the 500,000, I'm going to pay you to send the gearbox across, because that offer wasn't beaten, it was basically mirrored what the Court of Appeal ultimately found. There was a punitive costs award made against the seller. So it's another practice point and a point for clients to be aware of, is that if there's a real benefit, there can be a real cost benefit to making an early settlement offer. Yeah,
well said. It's a really important point, where ultimately what happened on this appeal was the appellant got the 500,000 odd, but got punished on cost because of the procedural posturing that they'd taken throughout both sets of proceedings. And so I think it's a good way to sign this off, Calum. Thank you for getting to the end of this podcast. This has been our longest, I think, comfortably. I almost thought it would be, because there's just so much in it. It's a really,
so much to deal with.
Yeah, really interesting case. I've enjoyed it. I hope you have as well. To all our listeners, it's always a pleasure talking about these cases with you, Calum. And thank you again to Rachel for helping put together these podcasts on the back end. Thank you all. Until next time, take care.
Perfect. That's the checkered flag.